Hello, everybody. I'm really excited that everyone's joined already, or a lot of people have joined already. And so we'll get started in just a few minutes. I'm going to get a few people an opportunity to join, and then we'll get started. It is your Saturday, so I am very grateful that all of you attended and took time out of your schedule to attend. And so this webinar is going to discuss the new USCIS policy on permanent residence in the US. So there's been a lot of news reports that have been out saying that USCIS is no longer granting green cards for applicants in the US. And that is absolutely not true. And so I think we've kind of gotten some people weren't reading the entire memo. They just kind of read just the title, or just some people are afraid of what this could actually mean because the memo is ambiguous or not quite clear as far as who they're going to allow to get permanent residence in the US and who they're not. So this presentation is going to give you some guidance and what to do and what not to do. And then we'll have some questions at the end for just if someone has some questions, so we can try to answer those and get you on the right track. All righty, so let's see. Let's go ahead and just get started. Okay. So we're going to cover quite a few things. So I'm going to respect your time and make sure we can keep this under an hour, but we're definitely going to make sure that we answer your questions as far as what this USCIS memo says and how it can affect your green card case. So first, let me introduce myself. I am attorney Tatiauna Holland. I am the managing attorney of Holland Global. And so we are an immigration and estate planning law firm. We have offices in Houston, Texas, Brooklyn, New York, and Accra, Ghana. And so we help clients in all 50 states and internationally with immigration matters. So we have been a firm through three presidencies. So that means Obama, Biden, and Trump twice. So we've seen all types of cases and we've dealt with very complex cases throughout the year. So we really wanted to put this together to make sure that the public at large understands what's going on. Okay. And the most important thing here. So this particular webinar is just for educational purposes only. Every immigration case is different. And so it is necessary that you do consult with an experienced immigration attorney about your particular case. So what you hear here is not to be taken as legal advice. You can't say, oh, Attorney Tatiana told me that this is what this means, and I'm definitely going to get approved. That's not how it works. I would still need to meet with you, or you would have to meet with someone else that could give you qualified legal advice about your particular case. We would love, love, love for you to meet with us and for you to hire us. But it is very important that you meet with just an experienced licensed attorney. And so, yes, we welcome for you to schedule a consult at hollandlawfirmplc.com/schedule. Okay, let's get into it. Alrighty. So last Friday on May 22nd, USCIS issued this memo, and we're going to provide these materials to you after the webinar, so you'll be able to click the memo yourself. But essentially, they said that they're only going to be issued permanent residence in extraordinary circumstances. And so what they did was saying, hey, there's going to be a lot of people who will not be approved inside the United States, and they would have to go through something called consular processing. And so the problem about this is they didn't actually define extraordinary circumstances. And they also made it a little too simple. Everyone does not qualify for consular processing. And so we're going to go through this in this memo or in this presentation. Okay, so what is adjustment of status? Adjustment of status is the ability to apply for permanent residence inside the United States. So essentially, if a person is admitted or paroled inside the United States, and they have a qualifying relative or petitioner, they will be able to obtain their permanent residence in the United States typically. That's the simple way of putting it. So if you have like a US citizen parent, US citizen spouse, permanent resident spouse, a lot of times they can apply for your permanent residence here in the United States as long as you entered legally. Okay. And so the common examples of being admitted or paroled are visitor visas, fiancé visas, or advanced parole. Now, this is a simplistic way of looking at it. It's way more complex than this, but essentially the way it goes is the person enters at some point, they have a a valid petitioner, and then they apply for permanent residence without ever leaving the United States. And this does include visa overstays. And so this is how this all gets a little hairy, okay? Consular processing. Consular processing is a kind of complex process. It really is. And so that's why this memo is problematic because it makes it sound like you can either A, get your green card in the US, or B, go through consular processing. And that's not an option for everyone. That's not how it works. Okay. So essentially, what happens if a person is already inside the United States and they have to go through consular processing later, there's a lot that we have to discuss, but I'm going to make it as simple as I can. So let's say the person is in the United States, typically without a visa, they entered without papers. But even under this new memo, this would include people who have been here for a while as visa overstays. Their US citizen parent, their US citizen spouse would apply for them, would petition for them. They would file the I-130. Once that I-130 is approved, this is when it can get a bit hairy, right? If the person is inside the United States and they have been in the United States unlawfully for 6 months or more, for a year or more, by leaving to do the consular process, they actually will trigger what we call a ban. They will trigger a ban in which they cannot come back into the United States for 3 years or 10 years without something called a 601A waiver. And so the 601A waiver is a hardship waiver in which you say, hey, if I were to leave the United States, it would be an extreme hardship on my US citizen spouse or parent. And if they had to relocate with me, it would be an extreme hardship on my US citizen spouse or parent. And so that's a whole different step that the person has to go through. And then once that waiver is approved, then they go to the consulate outside of the United States and apply for their what we call an immigrant visa, but a permanent resident card or a green card. Okay. And so now just leaving the US isn't the easiest part. There can be complications at that interview that could prompt additional waivers and additional time. So that's why this memo is really problematic because they're saying, hey, you can do this. Let's go. We can do this like three-step. Oh, let's go back. Sorry. We can do this kind of like three-step process of applying for permanent residence in the United States. Or you can do this very complex process called consular processing. And that's just not how it works. It's going to be a lot more complex for some people. Okay. And so why this memo matters. So I touched a bit on the 601A waiver. What's important is you notice that I said that you had to have a US citizen spouse or parent or permanent resident spouse or parent to even qualify for the waiver. What about those people whose children have petitioned for them? So when the US citizen child over 21 petitions for their parent, they don't have a qualifying relative a lot of times. So that's why adjustment of status in the US is the only option. And so when USCIS suggested, oh, just do consular processing, that's not an option for a lot of people because they're missing that qualifying relative. Okay. And this is also just my 2 cents. No one asked me, but I also have an issue because immigration law states that if a person is admitted and inspected, paroled and inspected, they can qualify for a permanent resident card, right? And so by adding these additional factors that they're not even clearly defining, they're affecting the law, which laws are stronger than policies. And so that's why a lot of attorneys really have an issue with this because they're affecting the law in a way that it shouldn't, it shouldn't. That's up to Congress. And so, yeah, so it's an unclear standard. They're not clearly telling us what extraordinary circumstances are. We talked about that 601 waiver that a person may need and may not qualify for. And then they have to leave the US. And no one talks about how a lot of times people who are applying for permanent residence, the US is really the only life they know. Or they've been in the US for 20 years or more. So if they were to return to their home country for this interview, they don't have family they can stay with. They don't understand how to get around. And so by having to go to this consular interview, it does make things a lot more complex. Now, something that I didn't discuss, the consular process is available for people who are already outside of the US and didn't come in, and they don't require a waiver. That's completely separate. We are talking about people who are already inside of the United States and they currently qualify for permanent residence inside the US. And so I touched on this a little bit. So the 601A waiver problem. And so the six, let's talk about processing times, how long these cases actually take. So currently the I-130, which is step one, the my child is a US citizen, my spouse is a US citizen, that petition takes about 13 months currently. And you can look that up on USCIS processing times if you Googled it. So you have to wait for that I-130 to be processed, and then you apply for the 601A waiver. And that waiver takes about 3 years currently to get approved. Now, if you had an aunt or a relative or someone that applied back in, like, let's say 2014, 2016, those waivers were taking about 6 months. But today in 2026, they are taking about 3 years. And so now you're 4 years into your process and you haven't even left the United States to get your permanent resident card. Meanwhile, the adjustment of status inside the US can take anywhere from 4 months to 2 years, and you never leave. And in the interim, you get a work permit, you get a travel document. There's benefits that will help you stay in the United States, get a driver's license, file your taxes, all of those things. But this 601A waiver that we talked about for being in the country unlawfully, now your process is 4 years, 5 years, and sometimes longer. And again, issues can arise when you're at the consulate abroad. Okay, so the memo said that they will grant permanent residence in the United States in extraordinary circumstances, but they're going to weigh some negative factors and some positive factors in your case. And so the negative factors that they listed included overstaying the visa, unauthorized employment, failure to maintain status, violations of parole or visa terms, fraud or misrepresentation, criminal conduct, and other concerns. And so the biggest one to me was the overstaying the visa, because the law says that a person has to be admitted or paroled and inspected. Okay, well, admitted and inspected, paroled and inspected. So that's going to be a large percentage of permanent resident applicants have overstayed their visa. The law didn't say that you have to be admitted and paroled and you qualify as long as the visa is valid for most cases. So by them adding that, saying, hey, they're going to weigh negatively, heavily negatively in your case if you overstay your visa, that's that's a big one. That's really stressful. And so that's why a lot of attorneys are like, okay, what else do you want us to do? This is going to hurt a lot of people in ways that you really didn't think about. And so what we have to do now is talk about the positive factors, the things in your case that will make them consider extraordinary circumstances. Okay, possible positive factors. So family ties in the US, education and certifications, stable employment or business ownership, financial stability and tax compliance, community service and good moral character, military service and hardship. So what I got from the memo and what I've been recommending for clients already is to just let's walk through how you even got into the United States. Okay. So if you came to the United States with a visitor visa 10 years ago and you didn't leave because you got sick, a family member got sick, you had a child, all of those different things, that's important. And then we'll also want to discuss your family ties in the US. How many US citizen and permanent resident family members do you have? Do you have 5 US citizen children? Do you have a US citizen spouse? What about your brothers and sisters? And we can create a family tree that shows, hey, my whole family is here. And we also want to discuss what family members do you have abroad? A lot of people have been in the United States for so long that they really don't have anyone left. I might have a grandmother that I kind of see on FaceTime, or I have an aunt that I heard about, but you don't have anyone that's really going to look out for you if you went back to your home country. And so that's very important to talk about. And then there's also your education certifications. So many people have been here for ages. So you've graduated from high school, you graduated from college, you took an English as a second language course, you got a CDL and you drive trucks. You got this award at work, you got that award at school. All of that is very important. And so they want to see that you've been here inside the United States for all of this time and you've been contributing positively. Stable employment and business ownership. So this one's a little tough because on one hand, if we go back to the previous slide, you can see that they discussed unauthorized employment. And that does also include business ownership. But then they say they want you to tell us about having stable employment and business ownership. So it's a bit of a catch-22. But one thing that you can do here is say, hey, I've been filing my taxes for the last 10 years that I've been here. I own a business. This is how much my business brings in. This is how many people I employ. I've been employed for this many years. I've got this many clients or people that I've been in contact with that are willing to give me letters of recommendation or show that I've been just the best employee or vendor service contact that they've had for ages. And that's the type of stuff that you'd want to include in your application. And I touched on it a bit earlier, taxes. Filing federal taxes with an ITN number is so important. Or if you were issued a social in the past, to continue to file your taxes because the government absolutely cares that you file taxes and you don't owe overdue federal, state, or local taxes. Also, they do want to make sure that your tax forms are accurate, that you are not including other people's children or people that aren't really dependents on your taxes. They want to make sure that, hey, you're filing with your accurate status, you're filing accurate dependents, and then you don't owe any state, federal, or overdue taxes. My favorite part is community involvement and good moral character. And so many people are like, well, I was a stay-at-home mom. I didn't have time to go to school. But you were involved in the PTA, you were involved in the community, you go to church, you tithe in church, you were involved in, community cleanup. So many of us give back on a regular basis. And because you have such a good heart, an altruistic heart, you don't think, hey, this should count. And so it can be a little embarrassing because you're like, hey, I go to church or I go to the community center because it's what I want to do. But in this instance, it would definitely benefit to ask for these letters on letterhead to discuss your involvement, how long you've been doing it, how does this affect the community, how much you really have an impact on, where you live. So that's very important. And military service and hardship factors. And so here's where we really want to discuss your military service or sometimes the petitioner. So your US citizen spouse or US citizen child military service and say, hey, look, here's their DD 214. They had an honorable discharge. That's my kid. I did that. Like you could say that, like I raised a good kid. I did that. Or I supported my spouse through this. Or if they're in the National Guard, the Texas State Guard, the reserves, all that, we can show their active participation in that. And this can also help with your case. And hardship factors. Right now, as long as that memo is in place, I do recommend that everyone start to gather things that would prove that it would be an extreme hardship on your US citizen spouse, US citizen child, US citizen parent, or permanent resident as well, if this case wasn't approved. And so this is where you really have to have a sit down and really think about all of the things that you do for your family. And so this is going to be, hey, I'm the primary caretaker. I take my husband to dialysis. I take my children to school. I have a grandchild that's autistic. I'm the one that's involved in their care plan. This is going to be all of the things that we have to show. Hey, we are a two spouse household. Like the both of us have to work. If I don't work, things fall apart. So that's when we show utility bills, mortgage statements, bank statements, all of those things that show, hey, we're just like any other American family. Money's tight. And so if I were to have to leave and relocate to this place I haven't been, this would be very hard on my family that would have to stay behind. So permanent resident applications, as long as this memo is in effect, are going to be robust. They have to be. So I know sometimes you'll have people that say, oh, I just want to provide my birth certificate, a couple bank statements, no, now it's going to be a very robust application in which you're like, okay, here's my family ties in the US, my permanent resident and US citizen family members. Here are their birth certificates. Here are my diplomas. Here are the time I made dean's list and honor roll. Okay, here are my 10 years of tax returns. Here are my bank statements. Here's my community involvement. Here's proof that I don't have a criminal record. You can get a criminal clearance letter from every county that you've lived in over the last 10 years. That those type of things will go a long way to prove that, hey, I am putting forth effort to show that my positive factors far outweigh the time that I entered and I stayed for whatever reason. And so the memo just went into effect on Friday, but the legal community, we've been in Facebook groups, we've had meetings, and these are 4 questions that the USCIS officers have been asking. I can't guarantee that these questions will be asked at your interview, and please keep in mind that policies are changing day to day, week to week. So these questions might change, but they're really getting at 4 distinct things. Okay. So question number 1. Why are you seeking adjustment of status from within the United States instead of consular processing? So this is going to be a question that could be a little difficult for a person who's representing themselves to answer. And so because this has a lot to do with eligibility. So a lot of times people will say, hey, I have to adjust status in the United States because my attorney just told me that this is the best process for me. I don't have a qualifying relative for a 601A waiver. You know, I don't have any family abroad that I could stay with if the consular interview doesn't go well, or I'm stuck in administrative processing and consular processing. Yes, they tell you you'll be out of the country for a week, but some people end up out of the country for months, sometimes longer. So this is a question that it's going to be very difficult for a person who's unrepresented to answer because it really has a lot to do with your background, what you're actually eligible for, how long those processes take, and all of that. Did you know that consular processing is an option? Question 2. Did you know that consular processing is an option? A lot of people don't, and that's no shame. A lot of people say, hey, I know I want to get permanent residence in the United States. I had a kid, I got married, my circumstances changed. A lot of people don't go into all of the details of knowing that. And I think this question in particular shows just how out of touch USCIS can be when it comes for the process. So a lot of this is, hey, I applied for what my attorney said was the best option for me. My attorney applied for what I actually qualified for. So that question is a little challenging to answer as well. And number 3, is there anything that prevents you from leaving the US and seek consular processing? This is the time to tell your story. So I would recommend actually preparing a statement, a notarized statement before the interview. Now it's very careful that because once you provide USCIS a notarized statement, it's like testifying. It's in the record. So you have to make sure that you're telling the truth, the absolute truth the entire time. But this is where you get to tell your story. Like, hey, this is what happened when I came to the US. Like, so many people have such sad stories when they come to the US. Like, I was running from an abusive spouse, or, I came here and then my mom got sick with cancer, so I had to stay here with her. Or I came here and had a child, and I was like, I want my child to be educated here. There's just so many stories, and you have to personalize that. And then you get to talk about the life that you built in the US. I own a donut shop and I've run it for the past 7 years. And I have this many employees and they rely on me. I have built a family and a community. I own a home. If I tried to sell it, we'd be in negative equity. It was my spouse's dream to own a home. So if I left, that we might lose it. And what will that do to them? My children are in middle school and in high school and they can't leave. They don't even speak the language of my home country. So what would I do? I can't just uproot them. This is the opportunity to tell exactly what's going on in your life, what you've built here in the US, and why you can't return. And number 4, why didn't you leave the US before your visa expired? A lot of times people have such complex stories. Like, hey, I was doing my best to try to get as much money before I could leave the United States, or, just different. I fell in love and I met somebody, or I was trying to figure out how to transition from a visitor visa to a student visa. All of those things are important. And so you want to have that conversation, preferably with a licensed attorney to make sure that your reasons don't get you into more hot water, but can also affect how your case is viewed. And so these questions could change, but I can totally see where USCIS is going because they just need to see, hey, why did you choose to adjust in the US? And did you come to the US with the intention of circumventing certain laws to do the process here versus waiting abroad? Okay. And so working with us, you can schedule a personalized meeting, but I actually want to go into the chat and see if anyone has asked any questions during this. So let's see. Hold on. I'm going to see if I can stop sharing my screen. I think I'm done sharing. Okay, so this question, I like this question a lot. What is the status of the spousal visa when the spouse is outside of the country and never made it to the US? Okay. Alrighty. So what is the current status of the spousal visa when the spouse is outside of the US and never made it to the US? So that is traditional consular processing that we talked about earlier. So that's where the US citizen spouse files the I-130 while the spouse is outside of the United States. When the I-130 is approved, the I-130 then, actually, let me share my screen with you. The I-130 then gets sent to uh-oh, let's go back. Okay, so with the standard consular processing, the I-130 gets approved and then it gets sent to some place called the National Visa Center. Once the National Visa Center asks you for some financial documents and all of that, then your case gets sent to your local consulate. You have the interview. This process can take anywhere from a year, 2 years, sometimes more, depending on the size of your country and how busy that consulate is. So for some smaller countries, you're like, I got my interview in like 3 months, 6 months. For some larger countries, that process can take 2 years. And so that stays the exact same. This is affecting people who are in the United States and they might have to pivot and then do consular processing after spending some time in the US. And does this memo affect 2-year green cards when it's time to renew for 10 years? Okay. So what this participant is asking about is the conditional permanent resident card. So when a person is married to a US citizen and files for permanent resident, when they've been married 3 years or less, they get a conditional permanent resident card. I like to call it a 2-year permanent resident card because you get all the same rights and responsibilities as a legal permanent resident. It's just conditions on it. There's more things that you have to do when that card is about to expire. So typically within 90 days of the 2-year green card expiring, the person has to file something called a 751, an I-751, which is a petition to remove conditions from permanent residence. And so what that person does is they say, hey, we're still married. We're living together. Here's proof that we're living together. They'll say, hey, we got a divorce, but I will show you that our marriage was real. Or I tried to stay in the marriage, but I had to leave. We had to separate because of domestic violence or something. Um, is this memo going to affect the conditional permanent resident or the 2-year green card? They did not specifically mention the conditional permanent residence, but it is very important to know that when you file any form with immigration, they have the right to reopen or look at past applications. So they do that regardless. You just don't know about it. So that's why a lot of these applications take so long because they do background checks. They look into your alien file or your A file. So they do have the right to look into past applications and make a determination on whether they felt like you just did this to circumvent immigration laws. But this memo in particular didn't address it. And so that's going to be a thing of when it's time for to remove those conditions to just make sure that you're providing as much information about, hey, this marriage is real. Hey, I did everything legally and lawful, and I should qualify for my full permanent residence. Hey, thank you guys for the questions. What if they are just a fiance? Okay, so fiance visas are only available outside of the US when you start the process. So with the fiance visa process, you actually file something called an I-129F, a petition for alien fiance. And that says, hey, my fiance is outside of the United States. And when that fiance visa is approved, they go to an interview outside of the United States, and then they come into the US, and then and not within 90 days, they have to get married, like the show 90 Day Fiance. They have to get married, and then within 1 year of that marriage, then they file for a green card. And that memo doesn't apply here because that person actually did go through the set steps of the fiance visa. They actually went to an interview abroad, waited and came to the United States, married within the 90 days, and filed for that green card within that 1 year. So that memo does not actually apply in this instance. You okay. So USCIS has a website where you can no longer see your case status. Is that because of the new policy? No, USCIS has been doing a lot of updates to their website, and it's happening pretty frequently. So right now, you can still see your general case status as far as if you enter into the receipt number and it'll say USCIS is still processing your case. USCIS has issued a biometrics notice, but they used to have this really cool like status bar, and it would let you know that, hey, it's been processing for 13 months and you have another this many months to go. That cool system doesn't really apply anymore. They don't have that anymore, which is really stressful for a lot of applicants because you're like, well, what do I do? So you really have to piecemeal it. You have to say, hey, I'm going to go to the case status website where you can say, hey, my case has been processing. And then there's a separate website if you just Google USCIS processing times. And then you select your form type, and then you select where your case is being processed. And it'll tell you that, hey, this case is taking 48 months. This case is taking 75 months. And then you have to kind of do the math. And then if you go to the bottom of that site, it'll say what is the receipt notice or receipt date of your case. And there you can see if they'll say, hey, you can submit something called an e-service request, which says, hey, my case is outside of processing time, you're taking too long, and they'll let you inquire about the case online, in which they send your email to a USCIS officer. But I'm going to be honest with you. All of these different systems and forms and they're not really helpful right now. So right now, pretty much a lot of the applications are being backed up. They say they're doing additional background checks or different things. So it is very challenging to see exactly where your case is if they consider it within normal processing times because you can't call USCIS, you can't send the email, you just have to wait. So it's a lot of anxiety. Okay, let's see. Is my length of lawful visa stay, employment, married for 6 years to a US citizen, house ownership, and a child already help my application for adjustment and early parole? So I don't know exactly what you mean by the early parole. That would be something we would want to talk about. But yes, those are the things that they do say help as far as positive equity. So length of visa stay, lawful visa stay. So if you're still within your lawful visa when you apply for permanent residence, that can be a good thing. Now, they sometimes can have additional questions on like, okay, well, did you commit fraud by coming into the US at all? Like you said you were coming to visit, but did you immediately know you wanted to get a green card? So that's something that can be talked about on a case by case basis. I wouldn't let that stress you out. Um, Lawful employment, married several years, home ownership, have a child, those things absolutely help. And it's just how you frame them and how you organize your application. So absolutely. How long does the K-1 visa process take? So the K-1 visa process, it all depends on your consulate. So where the fiance lives is that's going to be how long the process kind of takes. So the I-129F, that part is processed in the US, the petition for alien fiance, that petition can take anywhere from 6 months to a year, sometimes shorter. Every time I quote people a year, they get it in 2 months. But I like to tell people the long end so that they are not disappointed if it takes longer. But then after that petition is approved, then it gets transferred to the consulate abroad, and it depends on the size or how busy they are. And so you can actually look up visa processing times for that specific consulate and see how long they're taking. Sometimes they say, hey, once we get all of the financial documents, we can get you an interview in a month, 2 months. Some people take a little longer. But the K-1 visa process from beginning to end, a lot of times can take between 1 to 2 years. It's a process that if um, you've met this person within 2 years in person, and you have just like a stable relationship through WhatsApp chats and you're visiting each other, or the US citizen is traveling abroad, or you're meeting in third countries and you are FaceTiming and participating in each other's lives, that is a good option if the fiance is abroad. Can you file from any country to get an interview faster, or does it have to be your home country? Okay. So you would file the I-130 first, no matter what. And you can put in any consulate that you want on the application. Now, the problem comes in is, will that consulate that you listed, will they accept you? And so every consulate is different. And so we've done this a lot of times where we'll say, hey, our client is a citizen of this one country, but can they process in yours because they're working in your country? They have lawful work authorization. They're a resident of your country. Or a lot of times we say, hey, their consulate is closed. Would you please allow us to adjust in your consular process in your country? And that is going to be an email and a conversation with their particular consulate, and they have to accept you. So you can, but definitely that is an option if for a particular reason that person does not want to consular process in their home country. Now, you also want to keep in mind, do you have the right to go to that country? So someone can say, hey, like I would love to do my process in Brazil. Under your current citizenship, do you have the right to even go there? So that's going to be what matters. And that's going to be a case by case evaluation that you would want to have a discussion with your attorney about how that works. Oh, let me see. A correction is my length of lawful stay. Okay, so I'm assuming that you're saying that you have. I'm assuming this is a person who already has a pending permanent resident application, and you've applied using advanced parole multiple times or at some point during your process. Um, Traveling under advanced parole with the pending permanent resident process is just a benefit of having a pending green card application. It's so that let's talk about that offline because I'm trying to really grasp what you're saying. But what they're talking about in this memo is initial entry. How did you initially come to the United States? Or if you're some people who might have had DACA and then you got advanced parole and then you apply for permanent residence, there's just a lot of different ways. But if you're talking about the traveling through parole on an approved I-131, they didn't address that. But I don't necessarily, this is just my own view, not the memo. That is a additional benefit that a person got just from applying for permanent residence. So wouldn't say that would be like a positive or a negative thing. I think the biggest thing is like how did the person come to the United States initially? Did they adhere to all of the terms of their particular visa when they met the US citizen, all of that? Okay. And how does this memo affect applying for permanent residency after being on an H-1B visa? Okay, so I'm going to answer that one live. And so I'm assuming this person is saying that, hey, you're applying for permanent resident through employment. So this particular memo is really only touching on family-based immigration, family-based permanent residency. The memo also isn't going to penalize people who apply for permanent residency through VAWA, which is Violence Against Women Act, and other humanitarian forms. So it looks like they're really only focusing on the family-based immigration at this time. Okay. And what kind of services do you provide to help people get through the process? Ready to apply for my fiance and two kids at the Ghana consulate. So, yes, that was exactly what we were talking about with the fiance visa process. So our office, we have an Accra office, and so we do help people through the permanent residence, the fiance visa process from Ghana, but then also the permanent residence process while in the United States. So we talked about that a little earlier on the call. You file the I-129F petition for alien fiance. That's approved. Then we coordinate an interview at the consulate in Ghana. If that's approved, then you organize travel to the United States. Within 90 days of being in the United States, then you apply for permanent residence. So that is how it would work. Yeah, that's how it would work with the fiance visa process. Okay. Answer live. And will this webinar be available after? Yes. So this webinar will be available tomorrow for replay, and then it'll be available next week in Spanish for people who need translations of this particular video. So yes. But thank you all. This has been a great webinar. This has been really good because what we don't want is we don't want people panicking. Um, a lot of the news articles have said things like you can't apply for a visa, you can't get your green card in the US. That's not what the memo said. It's just the applications have to be better prepared than they have been for some people, and they just want to know more information. So we will continue to update our social media. We will continue to send out emails to our mailing list. And if you signed up for this webinar, we have your email now, and we'll be able to provide you updates on what's going on. I have a sneaky suspicion that this memo will not be around forever. I do think there'll be some litigation around it in the future, but but as of right now, this is what's going on. And this also does apply to people whose permanent residence applications are pending currently. So if you get called for an interview next month, grab that proof of positive equities. And they're even giving an opportunity for some applicants to provide that evidence in advance. If you work with our firm, we always submit that evidence in advance because we want the interview to go as quickly and as smoothly as possible. But if you are representing yourself or you're going alone, you want to bring as much proof of those positive equities to that interview so that the officer can see your ties, your US citizen ties, your good moral character, your community service, and all of that. Okay. Okay. So this is a question. So what is the benefit of hiring you versus going and filing yourself? You don't know what you don't know. And so a lot of times what people will say is like, hey, I will read the forms, I'll read the instructions, I'll ask ChatGPT, and then something goes wrong. And the one thing that happens a lot of times is hiring an attorney in the middle of your process, a lot of times is a lot more expensive than if you'd have hired them in the beginning. Because when you hire an attorney to do, like, let's say a request for evidence or a notice of intent to deny, now they have to kind of undo what you might have done that was harmful in your case. So that's the one thing that, I always tell people, hey, there's a lot of information out on the internet, go for it. But if you want to make sure that it is done correctly, you want to go to someone who does it on a regular basis. And so, we've done hundreds and hundreds of applications over the last 12 years. And so, it's just completely up to you. And so that's why we always say, hey, schedule an initial consultation. We can have a one-on-one, but there's always information out on the internet. If you want to do it yourself, you always can. But the difference is when a person isn't an attorney or they don't practice immigration, they don't know what they don't know. And so that can always get you into a lot of trouble. But yeah. Let's see. Oh, yes. And we're going to be doing more webinars like this. And so just please keep a lookout with the mailing list, and we'll be doing more of these on different topics. And so share with your friends, share with your family, and have a great day. This was great. Thank you so much. Mhm.